Good morning, Council, and welcome to the Thursday, February 10th, 2022 edition of the Kansas Court of Appeals. I'm Judge Anthony Powell, and I'll be our presiding judge this morning. We have 3 cases on our docket, and I want to apologize to Council. We had some technical snafus that caused us to be a little bit late in getting started, so we very much appreciate your patience. I'm privileged to have 2 distinguished judges, and Council might be interested in knowing that you all of us are former district court judges serving on this panel today. With me is Judge Kim Schroeder and one of our senior judges, Judge Jim Burgess, who's a retired Sedgwick County District Court judge. He and I had the privilege of serving together when we were district court judges together in Sedgwick County. I'll call our first case. It's State of Kansas versus Charles Moore, case number 123351. May I have the appearances of counsel, starting with the appellant?
May it please the court, Patrick Dunn, Deputy Appellate Defender, here on behalf of Charles Moore. May I please reserve 3 minutes for rebuttal?
Very well.
And may it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas, present and ready for argument.
Very good. Thank you, counsel. Mr. Dunn, you may proceed. You have 12 minutes.
I don't know. From past arguments, do you want me, for the benefit of the audience, to go through the facts a little bit, or should I just launch right in?
You can do that if you wish. I won't count that against you if you want to.
What we're arguing about, I'm going to just briefly, well, before I start, anything I don't get to, I want to submit on the brief. My intention is to touch on issues 1, focus more on 2, 3, and 4, and then if time, touch on 5. So with that, moving into the history, this is a case that originally went back to an aggravated indecent liberties with a child plea from 2004. At the time, Mr. Moore's criminal history included the following potential person felonies. We had a 1969 juvenile adjudication, which was purported to be soliciting or enticing a child to commit an immoral act. We had a 1984 Oregon first-degree burglary conviction. We had a 1986 Oklahoma first-degree sexual abuse conviction and a 1994 Oklahoma lewd molestation conviction. So there were 4 potential person felonies. At the time, the district court found Mr. Moore was criminal history A based upon using 3 person felonies. The Oklahoma lewd molestation from 94 was used to classify him as a persistent sex offender and doubled his sentence. He had a direct appeal at that time, which was unsuccessful. And then in 2014, filed a motion to correct a legal sentence, initially premised upon State v. Murdoch. That motion was denied, and on appeal, it shifted more to a decomp type issue. And this was all a challenge of his Oregon burglary, first-degree burglary conviction. That case is somewhat among the famous, I want to say trio, but it's 4 cases came down the day that Wettrich came down, one of which was Buell, one was Moore, Wettrich was 1, and the 4th is escaping me at the moment. In those cases, the court adopted a new test, what subsequently has been called a new test, requiring identical or narrower elements when trying to compare out of state or extra-jurisdictional crimes. Kansas Supreme Court was well aware that this case arose from a motion to correct a legal sentence. Nevertheless, it still granted relief and ordered the case remanded with instructions to re-sentence him, treating the Oregon burglary as a non-person felony. On remand, there was a new PSI. It reclassified the criminal history as C. 2 things changed in that PSI. First, obviously the Oregon conviction was now treated as a non-person felony, and it then, due to a change in the law, it reclassified his 1969 juvenile adjudication as having decayed. And then it did not include that 94 lewd molestation because it was, again, treating him as a persistent sex offender. The PSI was amended and and again, now he was classified as a B based upon the way sentencing enhancement happened. So now the lewd molestation could be counted if they use the change in the law for that. So the district court sentenced him using B. That went back up on appeal. On appeal, the state agreed that the lewd molestation had to go back to being not counted because the law in effect at the time in 2005 was the one that was appropriate to use. It also, there was a challenge to lifetime post-release, and they agreed to that. However, they now said, since this time, we've had Murdoch 2 come down and State v. Weber come down, which says, and therefore the Supreme Court, when it got rid of it, when it reclassified his Oregon burglary, should be wrong. But we don't know what's going to happen. So the Court of Appeals remanded for further arguments in litigation on the issue in the district court. Now we have a 4th PSI, and the 69 juvenile adjudication no longer decayed. The Oregon burglary was included, and the lewd molestation was excluded. We had criminal history challenges for that sentencing, challenging the 69 juvenile adjudication, among other things. And also, I believe the first degree sexual abuse and the lewd molestation. All those were denied, and here we are back on appeal because Mr. Moore is back to his original sentence that he received in 2005. So with that, I move into issue 1. And we acknowledge that this issue is probably going to hinge on the applicability of State v. Clark. However, we want to point out, first of all, we don't believe Clark was correctly decided for a number of reasons, but we acknowledge that this court can't overrule Clark. So that's an argument for another day.
So are you telling us that the sentence that was imposed when the crime was committed, or based on the law when the crime was committed, controls under Clark?
If under Clark basically reiterated Murdoch 2. Clark was a case where it was somewhat similar in that the case had gone up, and Judge Powell, I'm sure, is familiar because he was on the Court of Appeals both times that case came up. Clark received wettage relief on appeal. Then it went back, and the state didn't petition. It went back down. State then said Weber and Murdoch, and it went all the way back up to the Supreme Court, and they said, yes, Weber and Murdoch apply, and you don't get relief. That's what Clark said. This case.
So the law that applied in 2005 applies today.
If Clark applies to this case.
All right.
Then I'd like to hear why you think that's wrong, because doesn't that really control? That's sort of one of the main controlling issues in this case.
If Clark is correct, we think it's different for a number of reasons. First of all, Murdoch 2 had not come out at the time of Moore, and the fundamental difference being that Moore was a case decided by the Supreme Court. The decision was made in Moore. The mandate came from the Supreme Court in Moore. Clark never had the opinion of the Supreme Court the first time around because the state didn't file a petition for review.
So is your position a law of the case doctrine? Is that what you're relying upon here?
Well, two things. First of all, law of the case. But second of all, Murdoch 2 came down after this case was final and on remand. And what the state is now asking, and at the time, the court could have addressed this Murdoch type issue, Murdoch 2 issue, the first time around. Sedgwick County could have raised this then. There was nothing saying, everyone knew this case began with the motion to correct a legal sentence. That was an issue that could have been raised at the time. And instead, the state didn't, for whatever reason, I can't say. And frankly, it was another member of my office that handled this the first time around. But that was, I mean, you look in the first couple paragraphs of the Supreme Court's opinion, they acknowledged in the facts that this case came from a motion to correct a legal sentence. So that was the time. Now, so at the time, clearly it was possible to get relief on a motion to correct a legal sentence because that's exactly what happened here. Murdoch 2 changed the law. And now the state is seeking the application of a change in the law vis-a-vis Murdoch 2 to change the Supreme Court's, to revisit the Supreme Court's decision in what we would argue, I guess, Moore 1, the first time the Supreme Court got it. So we contend those are the fundamental differences there. If there's no other questions, I think more of my time is going to be spent on issue 2. And Judge Powell, do you have the time we started? I'm sorry. Normally I look down at the clock, but we started so late. I'm not sure what time I really.
Show you've got just under 8 minutes left.
Okay. So issue 2 looks at Mr. Moore's 1969 juvenile adjudication. And I guess, again, we're going to be, the burden of proof is going to matter here. We contend, because it seems logical and kind of obvious, that what we are dealing with here is a sentencing hearing. There was no sentence at the time of these hearings. If you look at the Supreme Court's decision, the relief granted was they vacated the sentence. So there is no sentence. There is no more litigating a motion to correct a legal sentence at that time. If anything, the state is attempting to litigate its own motion to correct a legal sentence based on Murdoch. So we contend that we're still at a sentencing hearing, and whether it be 4715 or 214715, the older statute, or 216814, the current statute, the state still bore the burden of proving his criminal history by a preponderance of the evidence. So with that,
Mr. Dunn, what do we do though about the, and that's a good point, but what do we do with the rule that says that a legal sentence can't be modified? And if your client's sentence back from 2005 was a legal sentence, then all the gyrations after the fact are really for naught, because if that sentence was legal at the time it was imposed in 2005, then we can't change it if it's legal.
well, a misclassification isn't a legal sentence. And we're arguing that it should not have been classified in his criminal history as both a felony and a person felony.
I know, but you're making the argument that, well, we're kind of starting back, we're kind of restarting the whole procedure because we vacated a sentence. And my concern about that argument is that, well, if we determine that the sentence from 2005 was a legal one, we don't really have the authority to change or vacate a sentence subsequent to that.
Well, the Kansas Supreme Court already said it wasn't a legal sentence. That's what happened in 2005 and 2018.
Okay.
But either way, if we look back at the 2005 sentence, and we're at a sentencing hearing, the question is it at the resentencing we're looking at now? You can always challenge under those the current 6820, or at the time, I believe it was 4719. You can always challenge the severity level or classification of the prior crime. That's not something that is limited on appeal. So challenging those, that is a potential challenge there. If we look at the ledger, which is the only thing that anyone could find regarding this conviction, and if we look at that, we can't tell anything other than he was a judge delinquent, and the title of it is molesting. There's no statute. There's no indication there was any counsel. It just tells us basically nothing. So with that in mind, we don't think it was ever even proven that what it was, or that it could be classified as a person felon.
Mr. Dunn,
Well, back
Mr.
in the
Dunn?
day in juvenile matters, if you were a delinquent, that was the functional equivalent of being a felony. If it was a misdemeanor, you were a miscreant. So that does tell us something. It tells us they proceeded under a felony violation.
Not necessarily. At the time, a delinquent could also be someone that had already been adjudged a miscreant 3 times. In which case, the conduct was still the conduct of a misdemeanor that we're talking about. So it's in 1969, Judge Burgess, I candidly will admit I haven't looked at I don't practice juvenile currently. Our office can only do felony appeals. So I don't know what the law says now, but I do know, and I had to actually sneak into the KU Law Library because this was in the middle of the pandemic and everything was shut down to find these statutes that were relevant to this. And at the time in 1969, a delinquent did not necessarily mean it was the conduct constituted an adult felony. So with that in mind, I'd also move into issue 3.
Can I, Mr. Dunn, I have a question.
Sure.
All right. As I understand the record, in 2005 at sentencing, Mr. Moore agreed that his pre-sentence investigation was correct and agreed with the designations on the PSI that his 1969 conviction was a person felony.
I don't think he specifically said that. What happened was the judge said there were criminal history objections at the time. They were admittedly, defense counsel withdrew them. Then the judge said, do you agree that he's criminal history A to counsel? And they said yes. And then the judge turned to Mr. Moore. I don't know if he turned, but the judge asked Mr. Moore, do you agree? And he said yes. So whether or not or he said, do you admit this? And he said yes. So I don't know that that's a specific admission that you're trying to narrow it to. But go ahead if you're going on.
Well, but under the law as it exists today, as his attorney, you have the burden to show that the classification from the 1969 conviction or adjudication, is invalid. Is that correct?
I don't believe that's correct. Again, we believe that since this is a fresh sentencing hearing, the burden still lies with the state because of a criminal history objection was raised at the time of sentencing. Again, so in 2020, the conviction, it's not a conviction, the adjudication was explicitly challenged at the trial court level. Therefore, the burden still rests with the state, whether you look at that under 4714 or 4715, the old version, or 6814, the current version, 21, and chapter 21.
Thank you.
But even so, we presented the only evidence that there was, the state provided the only evidence that there was. I'd note that if you look at that ledger, the only name on there is Sheriff Clarence Renner. And again, this is one of those rabbit hole things that when you're sitting in the waiting room before argument, you think I might as well look at. And lo and behold, Sheriff Renner either went to law school apparently, and subsequently became Judge Clarence Renner, and passed away, I think, in 1996. So there's no way we can go talk to him about this or present him as evidence of this. And we have no indication. The only records, again, we have are this juvenile docket. We don't know who the judge was. All we know is that there was a juvenile adjudication where he was judged delinquent, and a deceased judge was the sheriff at the time. That's the only possible evidence to present. And by preponderance of the evidence, I don't think that I think we can say we can't prove, no matter what that was, period. You can't prove it was a felony, wasn't a felony. There's no way to know either party. And we don't even know that it is a conviction. And that's kind of where we go into issue 3.
Mr.
If
Dunn,
we look at,
Mr. Dunn, you've used all your time, I'm afraid. I'm going to give you 1 minute to kind of wrap up. And if you want to just briefly state your argument or save it for your rebuttal, the rest of your argument, I'll let you do that.
well, okay, let me briefly finish on this issue because it covers the rest. And then the last issue, again, is going to hinge probably on Clark also. I'd like to gauge a gripe when the CSOs prepare PSIs about them guessing statutes. Here, we have no idea what it really was from that ledger. We can only speculate that the court services officer guessed that it was 38.711. However, what we do know from 38.711 is it is much broader. First of all, the acts of gross indecency or depravity are broader than sex offenses these days. Loudon says that. Obviously, sexual intercourse with someone underage at the time. But at the time, I'd also point out the age of consent at that time was 18. It's 16 now. So we don't know if it even would be a crime now at all. We just don't know that. And I'd also point out the state's intending to try and compare it to ag indecent liberties as a touching. The problem is, if we look back to Conley and Ta, a couple cases I recently looked at in a different case, in those cases at the time, the prior indecent liberty statute was held unconstitutional because it lacked the specific intent we now have. And at the time, they didn't have the specific intent that we had in 38.711. So likely that statute, if it was any kind of ag indecent liberties, was unconstitutionally vague and couldn't be included under 2168-10D9 or the prior 2147-10. And with that, I go ahead and whatever little time I have left, save for rebuttal. Thank you.
Thank you, Mr. Dunn. Mr. Gillette, I'm going to give you a generous 15 minutes.
Appreciate that, Your Honor. I will strive to not utilize it all. The defendant is serving a legal sentence, the same legal sentence that was imposed upon him initially in 2005, and the same sentence that should have been deemed legal in 2014. We are here today to do one thing, that is to make sure that the defendant has the correct sentence for his 2004 conviction for aggravated indecent liberties for having sex with a 2-year-old child. I think perhaps the best overarching way to characterize this case, Your Honors, is an instance of someone that looked a gift horse in the mouth. Mr. Moore improperly got relief in his 2014 motion to correct an illegal sentence. And had he just been satisfied with that, the odds of the state even recognizing that his sentence imposed, recognizing that there were other issues here, was probably pretty slim. But he started to make other challenges. We looked at everything closely as we thought we could, and we moved forward. And so I guess the first thing I would start with is on issue 1, this 1984 first-degree Oregon burglary. Clark is controlling, and Clark is very clear that in circumstances virtually identical to those in this case, procedural points aside, and whether the mandate was issued by this court or the Supreme Court are irrelevant. What is relevant is the legality of the defendant's sentence. So if Mr. Dunn wants to characterize my arguments as the state's attempt to pursue a motion to correct an illegal sentence, fair enough. Our one goal is to make sure that Mr. Moore's sentence is legal and that he serves it. The legality of the defendant's sentence is fixed. It is fixed at a discrete moment in time. We know that not only from the Clark case, but also Bradford, Newton, Weber, Murdoch 2, a slew of cases that have come out following the defendant's 2014 appeal that came out the same day as Wettrich. And they've basically told us that, you know what, Wettrich was a change in the law, and we were wrong to have applied it to any cases that were final before Wettrich came out. It literally is that simple. In this instance, the defendant's 1984 first-degree Oregon burglary, the only difference that between the statutes that was ever alleged was that the type of crime that could be perpetrated during a residential burglary. And the state has never shied away from the fact that Oregon did allow for any crime, whereas Kansas had a narrower list of crimes. But that doesn't matter, because in 2004, when defendant committed his crime, and in 2005, when he was sentenced, Vandervoort controls, not Wettrich, not the identical or narrower test, which I think even our Supreme Court may acknowledge was wrong. But it nevertheless is the law from its decision date until yet the statute was amended yet again in response to Wettrich, the criminal history statute. So defendant's 1984 first-degree Oregon burglary is absolutely properly included in his criminal history as a person felony. There are no procedural bars that the defense can throw up in the way, as we've set forth in our brief. Not the law of the case, not the mandate, nothing can prohibit this court from making sure that Mr. Moore is serving an illegal sentence, or is serving a legal sentence. I'll move on to what I have in my brief is issue 2, and it's defendant's issues 2, 3, and 4. The 1969 accost, entice, solicit a child under 15 years old. The very first thing that I want to address with this court is the burden. And to be absolutely clear, the law 2147-15 back in 2004 and 2005, and what is now KSA 2168-14, they're basically identical. And they set out a number of ways that criminal history can be established. Number one is if the defendant admits his criminal history, which he did in 2005. That has to continue to carry some weight, at least including here today. And there's a reason why, and I'll get to that as I come to the second way that criminal history can be established. And that is if the defendant makes no objections. The statutes are clear that if the defendant wants to challenge his criminal history, he has to do it. He has to say something. No one's going to know his history better than him. And in the absence of any objection, the PSI alone would satisfy the burden of proof. And then the third way is if there is an appropriate objection, then the state has the burden to come forth with additional evidence to prove the challenged history by a preponderance of the evidence. And while the defendant in this case would like this court to think that he actually challenged this prior, even in his most recent sentencing before the district court, that's not accurate. He withdrew his challenge to this conviction at that resentencing. He had initially challenged it and he withdrew it. The burden should be on the defendant at this point to come forward with something, anything, to suggest that his sentence was illegal based on the inclusion of his 1969 adjudication. He has not done so, and his sentence, that scoring is legal. Judge Burgess, to your question, miscreant versus delinquent, that is, I agree with Mr. Dunn that a 3-time miscreant can be a delinquent. Fortunately, I didn't have to go to the KU Law Library. I've had to use the WSU library before, but we had one of the books that was necessary. We just happened to have it here. The issue that I would point out here is that there's absolutely no indication that that this defendant was adjudicated a delinquent because he was a 3-time miscreant. There are no miscreant adjudications in his PSI. There's just the 1969 molestation. So we do know that this was a felony. Um, so then to briefly address the ledger, a couple of things I think merit note. Opposing counsel said that the ledger was the only thing anyone could find. I don't know definitively that that's true. And I don't know because the defendant withdrew his objection. If that objection had persisted, maybe it is the only thing that we have. Maybe it's not. Some of these people might be alive. I don't know. I would agree with Mr. Dunn that just out of sheer curiosity and looking at that ledger, that that the name Clarence Renner does stick out. He's the judge. And I think that this court could even, if you'd like, take judicial notice. He actually sat with a panel of this court in 1988. But it's just a fun aside. It lists sheriff, but Mr. Renner is the judge in the case.
Counsel, do you know as a matter of fact that he was a judge at that time, or was he a sheriff?
I'm going a little bit beyond the record here. I can tell you there's a historical website for out for Pratt County that has a historical mock-up of the courtroom from 1968 when they replaced the furniture, and a mannequin of Mr. Renner sits on the bench. But we are beyond the record at that point.
I'm just curious because, I mean, it's not unusual for someone to start out their career in law enforcement and then go to law school and proceed on. So
no, it certainly is not. But I believe that every indication that we have here is that he's the judge. This was a sheriff's case. I think you could even look at the docket sheet below and how it was recorded in a different offender's case, or a different case. It was a DWI. It doesn't preface the name Clarence E. Renner. Its sheriff is listed below, and that would have been in record volume 1, page 237. So we look at this, and as I set out in my brief, it's clear that molesting gets us to one particular provision of the statute that existed at the time. That is 38.711. There's a specific type of touching that applies to. I would also note that there are arguments in the brief about whether or not the state carried its burden to prove that the defendant was represented by counsel back then. However, I would note he has never actually claimed he was not. And also recorded in that ledger sheet, it's admittedly hard to read, but at the very top of the recorded column, the very left column, it says ad litem. And I don't think that it is any stretch for any court to make the determination, even if the state had the burden, that if this defendant had an ad litem, he had an attorney. And I cite in my brief the statute that sets forth the duties that an ad litem has, and those are the duties of a defense attorney. So I guess the long story short is the state believes that even if we had the burden regarding this 1969 adjudication, we've satisfied that burden here. And the defendant points to nothing that would suggest we have not, other than illusion. And that's part of why I point out these facts in my case, and as well as the Corby case that is in my original brief and the subsequent opinion I-609 this week. Illusion is not a claim. If there are no other questions on that point, I would then just say that, again, there is no decay of this adjudication as well. The statute was clear under 2004 214710 D6, because this was this prior sexual touching is comparable to sexual touchings in Kansas. Then it was properly scored under Vandervoort. Then it was a person felony and it couldn't decay. I'll ask if the court has any questions about those issues at this point. Then
There are questions, so Mr. Gillette, continue.
Then I guess I'd just briefly touch on the third issue, because I know Mr. Dunn wants to get to it as well. And again, I think we share the same goal. We just have different views on how we get there. We want to make sure that this defendant has a legal sentence. And his 1994 Oklahoma lewd molestation conviction was used here to deem him a persistent sex offender. Once again, this is another prior that when showed the documentation, the defendant withdrew his objection, even at the most recent resentencing. We've added the documents to the record that do evidence that prior under the appropriate Van der Voort tests, which this court must apply. We believe that those documents make it absolutely clear that this was a prior felony, that its closest approximation was a sexually violent crime in Kansas. Be that indecent liberties or aggravated indecent liberties, that fits our definition. As far as the newest thing that I heard today was a new argument regarding aggravated indecent liberties and the constitutionality, things like that. I would point out that a motion to correct an illegal sentence is not an appropriate vehicle to make a constitutional claim. And it is absolutely clear that that is the case. So that new claim today should be rejected. And if there are no further questions, I would simply conclude by saying there is absolutely no world in which our legislature intended a serial child sexual predator like Mr. Moore to have his prior adjudications and convictions for sex crimes against children not counted against him as person felonies and or sexually violent crimes. Again, the defendant is serving a legal sentence.
Thank you, Mr. Gillette.
Thank you.
Mr. Dunn, you have 3 minutes for your rebuttal.
Well, as passionate as Mr. Gillette's conclusion was, the legislature doesn't look at individuals. The legislature makes statutes on what they are, and the rule of law applies those statutes to everyone. So what really matters is not what he may have done or not done, is what matters is what the actual law is. Now, the first thing, kind of taking things backwards, what I mentioned before with respect to indecent liberties is not a constitutional challenge. It's a statutory rule. The statute in question that I was referring to is KSA 216810 at this point, D9, which says a crime committed under a statute which has since been found unconstitutional shall not be included in one's criminal history. That's not a constitutional argument. That's a statutory argument. That same statute has existed with virtually the same language since the guidelines were enacted in 1993. And I believe it was 214710 D or E10 at that point in time. The language is unchanged. You cannot use things that have since been found unconstitutional. The indecent liberties statute was found unconstitutional as being overbroad in 1975 in State v. Connolly. Therefore, it's Conley. That was recognized in State v. Ta just a few years in 2012 by the Kansas Supreme Court. And the reason being is it lacked the specific intent element, that you do it with the intent to arouse the victim, offender, or both. So we're not making a constitutional argument. We're saying the statutes aren't comparable. That old statute was the same unconstitutional statute as was the case in Conley. Another, I hesitate to mention this too, another rabbit hole I went down was looking at the notes in 1990 in the statutes to the nets at that point even repealed 38-711. And what they said, it's interesting, it said in the Judicial Council notes is it was meant to be now taken care of with the recodification in 213507 through 253511. 2507 was adultery, lewd and lascivious is 08, 09 was enticement, 10 indecent solicitation, and 11 is ag indecent solicitation. And if you look at the Judicial Council comments, to ag indecent solicitation in 213511, and you have to pull up one of the old statute books that has these. It says that was what was meant to cover 38-711 at the time. That was what, when they repealed it and recodified, that was what they intended. And they specifically, if you look at ag indecent solicitation, it's enticing someone under 12 to commit unlawful sexual conduct. That simply is not the same conduct that's covered in 38-711. The old, in 1969, it was much broader than that. So we can't say, most likely that was what they intended to be comparable, but that's not what was comparable. Even under Vandervoort, those aren't comparable. So for that reason, in addition to all the reasons cited in my brief, we would ask this court to send things back for resentencing. Thank you.
Thank you very much, counsel. We appreciate your excellent arguments and wading into this one, and we'll get you a written opinion as soon as we're able.